Hello, my name's Greg Kish. I'm an attorney who practices probate and estate planning law in the Grand Traverse Leelanau County areas. In this segment, I'll be talking a little bit about the role of a conservator. Before we get started, it's important to note a couple of important terms that will be used when you're talking about a conservator. First is the word protected individual or protected person. This term is defined in the conservatorship law as a person for whom a conservator has been appointed or for whom the court has issued an order protecting that person's financial or business resources. The term is really important because it guides everything we do with regard to conservatorships. The idea behind a conservatorship is to protect a person who needs help protecting their own financial security. A conservator is a person or sometimes a bank appointed by the probate court to handle the business and financial affairs of a protected individual. A conservator may be a full conservator with responsibility over all of the person's property and income, or it may be a limited conservator with only certain responsibilities over certain assets. Finally, the word protective order. Protective order is a term to describe an order issued by the probate court that authorizes a particular financial transaction. It may or may not involve a case where a conservator is appointed. It's essentially the court giving its approval for one particular transaction. Now that we know some of the basic terms, let's talk about why a person may have a conservator appointed for them. In general, a conservator is most often appointed when a person has become unable to manage his or her business or financial affairs because of physical or mental illness or infirmity. In some cases, though, a person who is competent but who is of advanced age or illness can go and ask the probate court to appoint a conservator for him or her. So a protected person may or may not be a person who's competent to handle his or her own affairs. But in either case, it's a court has been appointed to handle that person's financial affairs for them. A conservator's authority comes from the conservatorship law and also from the court's order. In general, a conservator has almost all of the same power and authority over a person's income and assets as that person would have had him or herself. However, to fully understand your role as a conservator, it's important to read the court's order that appointed the conservator, as well as the letters of conservatorship. Letters of conservatorship are a document that the court issues that says who the conservator is and the scope of his or her authority. In general, the law places certain restrictions on a conservator. For example, a conservator cannot sell or mortgage real estate or sell a person's principal dwelling without the approval of the court. But some courts add additional restrictions to the letters of conservatorship, such as restricting expenditures over a certain amount or sales of other assets. So to fully understand a conservator's authority, looking at the letters of conservatorship and looking at the court order is important. Even though a conservator has all of the authority over income and assets that a person would have had on his or her own, it's important to remember that that authority does not come without responsibilities. The responsibilities that a conservator has are called fiduciary duties. A fiduciary is someone who is charged with handling another person's affairs in the other person's best interest. So in this case, the conservator has a fiduciary duty to handle the protected individual's money and property in the best interest of the protected individual. What does that involve? It involves acting reasonably and prudently. This means staying organized, keeping good records, being attentive to details, being responsive to issues that impact the protected individual's estate, being a good steward of the estate for the benefit of the protected individual, avoiding undue risks and not investing in risky investment products. And all of these responsibilities are required of a conservator, even if the protected individual had not historically managed his or her estate very well. Conservators are held to a higher standard. Part of the fiduciary duty of a conservator involves avoiding conflict of interest and self dealing. A conservator must always manage a protected individual's estate solely for the benefit of the protected individual and, in some cases, his or her dependents. The conservator cannot personally benefit or benefit his or her family members by use of the conservator's estate. Before entering into any financial transaction between the conservator and the protected individual, or the protected individual and a member of the conservator's family, it's important to make sure that that is a fair and reasonable transaction, that it is the best deal that can be had for the protected individual, and that the court approves the transaction before the conservator enters into it. Finally, part of the fiduciary duty of handling the estate in a responsible manner is to avoid commingling funds. This means that it's not acceptable for a conservator to transfer the protected individual's assets into the conservator's own name, or to mix the conservator's personal funds into the protected individual's accounts. Once in a while, it may be necessary for the conservator to spend some of his or her own money to purchase something for the protected individual and then be reimbursed. But it's important that those transactions be kept as rare as possible, be well documented, and be reimbursed with an adequate paper trail so that any third party looking at an accounting or records can tell that the conservator was not commingling funds of his or her own with the protected individual's estate. Another important aspect of a conservator's duty is to work to manage the estate in a way that maximizes the independence of a protected person. A conservator is required by law to make a determination as to how much money, if any, the protected individual can handle on his or her own, and should encourage the maximum amount of self-reliance and independence that is possible. A protected individual can, in some cases, manage his or her own checking or savings account with the prior authorization of the court. It's important to note that even though a conservator is charged with handling a protected individual's finances, and the protected individual is not making his or her own financial decisions anymore, this does not affect the protected individual's ability to make his or her own medical and personal care decisions. A conservator's involvement in medical and personal care decisions is usually limited to paying valid bills that are incurred by whoever the medical decision maker is, whether that's a guardian, a patient advocate, or the protected individual, him or herself. Because a conservator's authority really involves stepping into the shoes of the protected individual, when the protected individual dies, so does the conservator's authority. Once the protected individual has passed away, it's important that the conservator stop financial transactions like bill paying that may have become routine over time. It might be tempting for a conservator to pay last medical bills or other bills that were due or may become past due, but unfortunately that's just not appropriate for a conservator. A conservator can file with the probate court a petition to use funds in order to arrange for funeral and burial expenses, but should not pay other bills after the death of the protected person. Conservators manage the money and property of some of the most vulnerable members of our community. Having adequate financial resources relates to a person's standard of living and relates to the options that he or she may have to purchase high quality medical and personal care. In short, the good work of conservators relates directly to the quality of life for the protected individuals involved. It's an important position of trust, and the role is very important in our community and in the probate law. Thank you.